Harvey, I'll do it right.
The Superior Court for the Hartford Judicial District is now open in session. The Honorable Ami Sheikh presiding. Good morning, Your Honor.
Good morning, Your Honor. Good morning, everybody. Go ahead and call this.
Sylvia Ho, I represent the company. Sylvia Ho, I represent the company.
All right. My hope for today's hearing is, counsel, I'll give each counsel 30 minutes for argument. If you want to reserve any time, Attorney Strame, for a reply, that's fine. And obviously there's extensive pleadings and, filings and affidavits, which the court, has begun, review of. So obviously, I can read all of that. I guess what I'd want to hear, Attorney Strame, is anything additional, or kind of highlights, from that. I think that'd be most effective use of the time, but I leave it to you. Whenever you're ready, go ahead.
Your Honor, I'd reserve half my time for rebuttal. And I see my purpose here really to answer the court's questions. So I have an argument here, but really I'm really here to answer whatever questions the court may have. That's why I'm here. So this is we have 8 counterclaims here that target my client's speech in connection with his trying to go to the court to get an accounting and dissolution. That's petitioned protected activity. That's the right to petition. Every one of the counterclaims targets speech in connection with his right to petition. And this is all in connection with a public-facing business, a martial arts school that teaches children, in the defendant's own words, instills in them the virtues of honor, integrity, respect, and integrity in his students. I note that in the defendant's affidavit at paragraph 28, that's docket entry 120, and I talk about that on page 13 of the reply. So first, step 1, step 2, right? This is a 2-step, as the court knows. The first issue is whether the counterclaim is based on our right to petition. They only brought the counterclaim after we exercised our right to petition. Now, that doesn't mean every counterclaim is going to necessarily be based on someone's right to petition, but the timing, as we highlight.
Because then you'd have a special motion to dismiss in every case, right?
All the time, Judge.
Right.
But
but like every business dispute between a closely held corporation or minority shareholder dispute, right? Like, I mean, it'd be endless. The courts would be flooded with special motions to dismiss.
That's absolutely right, Judge. But it is a factor for the court to consider the timeliness of things. If, in fact, these counterclaims were genuine, why did they wait so long to bring these long-standing issues that ostensibly, it's a curious timing. It's
well,
not,
I mean, but is it though? Because I mean, your client filed suit, right? So I mean, a lot of times businesses just have disputes. They've got resolutions. they're working behind the scenes, they're working with each other, they're working with the mediator, they're working with friends, families. I mean, you name it, to try to resolve things before actively litigating, because then you're starting to spend money not on the business, right, but on lawyers.
Yes, Judge.
And so, you know, I can see in any business scenario, even one where, you know, there's a minority shareholder, and, you know, depending on the states you're in, whether or not minority shareholder laws are going to be favorable to you or not. And so maybe you're better off not litigating. But, you know, once litigation is commenced, you've now changed the landscape. And yeah, it may take time to gather documents, gather things together, gather a strategy, gather a lawyer, and then file possibly a counterclaim. All right, go on.
Sure. So I would also direct the court's attention to the kind of relief that's sought. Where
Okay.
they're seeking an injunction, an injunction right at the outset to stop my client from talking. That's something they're looking for immediately. Now, that since Neer versus Minnesota, almost 100 years now, that's something that they can't get in a defamation case. That's not allowed. They didn't even try to make a showing as to trade secrets. There's none of those elements are there for CUTSA. They don't have the right to go seek in a defamation case an injunction against someone using words. In the filing they talk about, they filed yesterday on page 38. They use a word that sounds kind of like apple, but it refers to part of the anatomy that usually is we use it to mean someone's a jerk. And it's page 38 of the filing by my adversaries yesterday. They're specifically targeting
filing 153. Which filing?
It's the most recent one. He says it's preliminary statement.
The 152, Your Honor.
I think it's 152. I have it down as 152, but I might got that.
All right, no, I know it is.
What page was that? What page?
Page 38, bottom of page 38.
All right.
So,
All right.
for example, Andrew's statements that Mr. Shirley was a jerk, but that's not the word, abuser, manipulated, controlled him, etc. He says, these are statements of fact. This is what he alleges here. This is what the complaint is based on. Certainly count one is. And they use this defamation, these ostensibly false statements. That's what they're leveraging into the tortious interference. All the tortious interference counts, all the counts are based on ostensibly falsifiable, ostensibly statements. So they're trying to stop my client from talking. Okay. Is it that my client's speech, both people have, it's not a particularly onerous burden for either of us. Right? I have to show it's an issue of public concern, more likely than not, that it's based on our right to petition. They have to show probable cause to succeed. Neither of us have particularly onerous burden.
Right, but the burden first starts with, I think you'd agree with the
sure,
applicant on demonstrating, getting over the threshold of a matter of public concern, correct?
Yeah, yes, Judge. So, and I direct the courts in our brief, really, I rely principally on our papers, right?
Okay.
I think I handle most of this really thoroughly in our brief.
All right.
And there's two cases that talk about the issue of public concern from our appellate court not that long ago.
Okay.
And one of them is Pryor versus Brignol. There's a footnote, and that refers to another case that begins with M. I think it's Melanchick.
Mulvihill. It's Mulvihill.
Yeah, thanks. Mulvihill. Yeah. And that Judge Elgo's expressing some skepticism about the statute. But she says, as it's written, it's really broad. It seems from her view, as she's looking at the statute, it applies to any public-facing business, which we unquestionably have here. We don't just have a public-facing business. We have a public-facing business.
Is that a holding, or is that dicta?
That's dicta unquestionably, Judge, but
Okay.
I think it's a good view of how the appellate court looks at things. Judge Elgo's written most of the really important anti-SLAPP cases here.
Okay.
And it was joined by her, by two other judges, both of those cases. There's nobody to
I think it's important to read the actual language.
Hey,
hold on. Attorney Wilson,
Fair enough.
Yep. Don't, all right. Attorney Strami.
Unquestionably dicta, Judge. So let's look at the other end where we have people where something is not an issue of public concern. Chapnick is a really good one. DeLauro, Chapnick versus DeLauro. I like it a lot. Judge Levine opinion, 2022. And that is a case, they said this is clearly not, right? So it was speech about where, as a free speech lawyer, I like it too, because it's got kind of funny facts, but it's speech about where a dog does its business ostensibly near somebody's open window on private property. Okay. So a dog defecating on private property, where a dog does that business. Speech around that, even speech to a police officer around that, that's not an issue of public concern. A private dispute between two people. There was another case, a private dispute between two people, even if they're trying to seek an order of protection, a civil order of protection, but it's really just a private dispute between two people, doesn't affect other people. That's an issue of private concern. Here we have a business that serves children and is public facing. And we're talking about whether it's being run ethically, properly. We're trying to open up the books on it. Parents are investing in this and their children, they rely on this, not just for childcare, but this is part of the education of their children.
Right, but I mean, I guess what I'd ask of Attorney Strami is, there are tons of businesses that serve the public, right? I mean, we grocery stores,
Yes.
Car part stores. I mean, restaurants. I mean, where's the line, right?
Well, it's not state act. It's grocery stores are generally speaking. If we took that dog in the middle of the grocery store and there was an issue about whether the dog was defecating in a public park or defecating on private property, but a public business, a business that serves the public, that's public facing, like a grocery store. Yeah, that's an issue of public concern. Is there something
I guess what I mean is, say there's a dispute between the owners of the grocery store, right? Because that's what you have here, right?
Yeah.
The owners of a car part store, the owners of a restaurant, right? How is that internal business dispute? Where does that then blend over to a matter of public concern? Where is that distinction? I get that you've got a martial arts studio here that people can choose to attend, right? They can choose. They can choose to attend it. They can choose not to attend it. They can also leave at any time. There's no obligation on anybody to go learn martial arts, right? So
that's right, Judge.
So how is it different?
I'm sorry.
Go ahead.
It's particularly because it's targeting. We're talking about something that serves children. Connecticut puts a special premium on the interests of in terms of children. We have that statute. I know the court knows about. It's a C felony to endanger the morals of a child. 10-year felony. That's how important it is relative to children. And here we have a business specifically about the morals and virtues that it instills in children.
So that's the difference, because it's kids.
It serves children. It serves parents vis-a-vis children. I think that is one of the major differences between a grocery store that doesn't necessarily, or a private corporation that doesn't actually go out and serve individuals in the community. It just is but the court said a mechanic shop.
Yeah.
You're not targeting children with that. That's not about instilling virtues into a child. So it's a particularly different category.
So you say something like, I mean, and I'm not saying I'm agreeing with your distinction, but you're saying, okay, there's like gymnasiums, ninja gyms that kids can go to for lessons on how to be a ninja warrior, and they do all kinds of acrobatics there or whatever, and it's mostly for kids, right? So maybe adults can go too. So I mean, but how is that meaningful? I mean, I get you're saying it's meaningful because it's children, but in terms of this distinction, in terms of why it's a matter of public concern just because it's kids, I don't know.
Well, that is a factor, Judge. And I think that's a very meaningful factor. It's not the only one. But I don't know whether I'm sorry, Judge.
Yeah, go ahead. Keep going.
I don't know that the ninja gym is instilling virtues in children and claiming to be virtuous, taking virtue very seriously, and trying to instill in them. This is defendant's affidavit. I'm not making this up. This is what they said. Trying to instill these kinds of virtues, integrity, honesty. These are the teachers. This is the head teacher. This is about whether he acted with integrity vis-a-vis operating the business.
All right,
That's an issue of public.
You got about 3 minutes left, Attorney Sarmi. So
Okay.
hit whatever you haven't hit it now.
Sure, Judge. Health or safety. It's also about health or safety. I would just note that it's not just about health or safety is an issue. Proper ethical and moral rectitude of children. I talked about Chapnick. Just going through my notes real quick.
Yeah.
As to the failure of probable cause showing, they basically have abandoned the field on that. They don't even try to refute the issue of standing. The only use of the word standing in their brief was as part of the word long-standing. That's a major issue we have in terms of the merits. Step 2, their ability to show probable cause. They don't even try. Their entire argument's predicated on step 1. So if there's no other questions that I can address for the court, that's really all I will I look forward to responding to my adversary's statements.
All right, thank you, Attorney Sarmi. I appreciate that. And I appreciate you respecting the allotted time. Attorney Wilson, who's going to be arguing? You or Attorney Ho? Are you going to be splitting it?
No, I'll be arguing. I represent a different defendant formally than Attorney Ho does.
Okay.
So, we should be viewed as different, as different defendants for purposes of argument time. I would submit.
No, that's fine. So I guess, that's why I'm asking is, are you going to do one argument? Are you both want argument? What do you
Your
want?
Honor.
I have no idea if she's going to have any argument or not.
All right.
Your Honor, I'm neutral in this because I'm a performer defendant that
Okay.
needs to be defended.
All right. So Attorney Wilson, go ahead. You have 15 minutes. And if you want to, actually, it's up to you. Do you?
I'd like to. Yes, I would like to reserve, 15 minutes for a rebuttal, afterwards. So I think, with respect to, I think it's pretty obvious disagree with just about everything opposing counsel has said. I think it's really, really critical that we look at the actual wording in the footnotes in Pryor versus Mulvihill, as well as in both Pryor and Mulvihill, because what those footnotes talk about is the defendant's arguments and, frankly, the court's refusal to adopt those arguments. And moreover, those are specifically limited to, meaning the extension that he's arguing for, even in that context, was specifically limited to licensed professionals. And it has not been adopted as the holding in either of those cases. And specifically, the language in that footnote in Mulvihill says, if the defendant here is correct that a real estate agent's conduct is a matter of community concern sufficient to preclude actions regarding defamatory statements, is the same not true for the conduct of other licensed professionals in the community, such as teachers, childcare professionals, or plumbers? Other licensed professionals. We are not talking about a licensed business here in terms of a licensed professional in the way that they're talking about one there. So even to the extent that there may be some suggestion that this broad language might be read with respect to licensed professional businesses, that is not in any way any sort of extension to this business. And frankly, any sort of holding in that arena would be to invite error, would be a violation of the statute, and would be a clear violation of my client's constitutional rights. And
what does one need to open a martial arts studio in Connecticut? What are the requirements?
I'm not sure what the requirements are, but it's not the same as a licensed plumber or a licensed childcare provider, right? I believe that there is some form of business license associated with effectively any business operating in Connecticut.
All right, so martial arts studio, donut shop, it's a business.
Exactly, it's a business. And the case law is crystal clear that business.
So I could open one, you could open one. There's no litmus test on the requirements of who's opening up a martial arts studio. In
terms of qualifications, that I'm not sure, Your Honor, but I can't imagine that there's some sort of specific requirement that's so divergent from the donut shop context or anything else that might be of any relevance to this dispute. Furthermore, I think it's crystal clear. Let's look at the complaint. You know, I'd invite the court to parse the complaint and see where the virtues of children are being vindicated by the complaint. It just simply doesn't exist. Every single count in there replies or deals with very specific complaints that Andrew has about Mr. Shirley. Just a dispute between the two of them, exactly the way that Your Honor pointed out with respect to equally applicable to any business. If we go down this road, you're just opening the floodgates, and this is specifically a set of floodgates that the courts in Connecticut have specifically closed, including in the Chapnick versus DeLauro case. I mean, suggesting that just applied to one or two people is not actually true. That was within the context of a condominium complex, and the court specifically, and I've pointed it out in my briefing, which I think is exhaustive, because I wanted to make it very clear why we consider this case completely inappropriate and frankly frivolous, as I've very clearly laid out, including contrary to what my brother has mentioned with respect to the probable cause side of things, should we get to that, which I don't think we even get to, Your Honor. I think it's very clear that we never even get there. But with the proposed findings of fact that I've provided yesterday for the court's convenience to facilitate understanding the length and depth and breadth of the statements involved here, and I did have a set of video clips that I was going to show and would like to show by sharing my screen if that's possible at some point.
I think I can rely on the affidavits for this hearing.
Yes, you can. All of these statements have been included in the affidavits. Suggesting that we haven't presented evidence from which the court could find probable cause is simply incredible. And suggesting that we somehow don't have standing to present probable cause is just, I don't think accurate at all. But again, if we look at the relief requested, right? Focus on the relief requested in the complaint. The complaint has to be on an issue of public concern. It is not. The case law is very, very clear. We have Chapnick versus DeLauro. We have the Cohen versus Myers case that is very clear on what public concern is and what public concern is not. In Cohen versus Myers, and I'm not sure if the court has had a chance to review that case yet or not, but that case involved someone who sued their contractor, who was also a building inspector, and then launched into all sorts of public vitriol, very similar to what Andrew has done here with respect to that business dispute, and accused him of having venereal diseases and cheated on his wife and all sorts of crazy stuff, very similar to some of these statements that we've proved are demonstrably false. I mean, for example, the most illustrative one is this text statement that Andrew says that my client threatened him with physical violence, that it took months and months for us to get from the plaintiffs after multiple requests. And when they finally gave it to us, it was only a clipped version of it taken out of context, where you have, and I believe you've probably seen it, and if not, you will. And then when you compare that to what we were forced to get through the discovery process, which is a full context statement, making clear that, yes, there was the statement, yeah, if you don't go home, then I'm going to come and, I'm going to beat the shit out of you, right? Something along those lines. But in the context, it is very clear that this was Mr. Shirley on the evening of a storm at about 10 o'clock at night, emphasizing to Andrew that Andrew needed to go home to his fiance and should not be at the studio. But at its base, that is solely a business issue. That is solely a personal dispute between the two of them and the personal relations between the two of them. And the same is true with respect to every other statement that we've identified. And to the extent that there's some suggestion that some of these might be opinion or some of these might be the truth, those are defenses that Andrew bears the burden of actually proving. And so as much as he may try to throw that burden onto us to prove their falsity, which I believe we have in substantial part with respect to many of them, and can provide further information to the extent the court needs it, at base, they're his obligation to prove the truth of. And the only thing that he has offered is an affidavit saying they're true, including in document 153, which is an affidavit from Andrew, again, a conclusory affidavit that would not pass muster at summary judgment stage, stating that everything that he said is either true or non-actionable opinion. But that doesn't clear the hurdle, right? The initial hurdle is proving that there's something involving public concern that's being vindicated by the underlying complaint here. And the same is true with the counterclaims. As I pointed out in my surreply, neither the complaint nor the counterclaims actually identify specific statements, right? That's critical because in California, the courts have said very clearly that if that's the issue, then you need to file a request to revise or some sort of request for more definite statement in order to reveal what those concerns are. So if you just look at the complaint or the counterclaims alone, they don't provide any means from which the court could find that there's any sort of public concern involved here. And then when you dive into the actual statements as well, you'll see the same thing. Every single one is either a video taken in the studio between Andrew and either students or employees or business associates of Mr. Shirley's. It's not Andrew in the newspaper going after Mr. Shirley and saying that he's, that he's compromising the virtue of children.
So it's limited to
it's
limited to people who voluntarily chose to attend
to be associated with the business. Correct.
People who could leave at any time.
Correct.
And there's no obligation for anybody to be there or to listen to what's going on or be involved with the dispute. These are all basically private participants in a studio that exists that's open to the public, but that's where it stops.
Correct. And again, the key is to focus on the context, the content. This is at the first stage now, and this isn't touching on the merits, but the context, content, recipient, the number of recipients, and the venue, right? In this case, it's all in a place that's accessible to the public, but essentially a private business involving participants solely associated with the business, none of whom have an actual interest in this litigation. And that's a really key point here. In Siccaginano, the court said that in order for something to be in connection with something of public, with a petitioning activity, that person has to have an interest, in other words, a stake or a role or some sort of participatory component requiring their participation in the petitioning of the government. And it's petitioning of the government, right? Everything you see here, to the extent it may be petitioning anything, it's Andrew not petitioning the government, it's him petitioning potential targets for the business that he was trying to slide off and take with him. And also,
the business could close at any time, right?
Correct.
Right, and then not available to the public, right?
Correct.
Okay.
And more importantly, I think the suggestion that somehow all of this case ties to the defamation counts is just absurd. We've provided significant evidence demonstrating that Andrew compromised the business because of his breaches of fiduciary duty. He's talking about passwords for computer records. He's talking about, business numbers, business finances, private business finances, all stuff that is purely private business transaction oriented, right? There is not a single stitch of anything relating to public concern or public debate or something that warrants public debate. And the fact that he filed a complaint doesn't by itself give him the right to protect those facts from being used as counterclaims against him. There hasn't been a single case that's been offered that suggests anything like that or anything even remotely like that.
You got about 2 minutes, Attorney Wilson.
Okay. So I think it's also critical to understand that the cases in California extending on this principle, the principles laid out in the Chapnick case and in the VD versus Robinson case, which adopts the Weinberg holding from California, which is, kind of 20 years ago, kind of set the standard for why things are not public concern if they are in the business context. We've provided a slew of cases holding that cases raised in a business context are frivolous and actionable. And that's been known, and we've gone into great detail as to how and why that was known by the plaintiff before the filing of this motion in the first instance.
All right. Thank you, Attorney Wilson. All right, Attorney Starmay, go ahead.
Before we go on,
Oh, sorry. Yeah.
Judge, what is required of a martial arts studios in terms
Judge,
of license?
I'm going to object to
Hold on.
Attorney Ho's participation in this.
It's to answer
Hold on,
the judge's question.
Yeah, sorry. Yeah, if Attorney Ho, if you know, and because I asked the question, what is the requirements for martial arts studio?
I'm going to
It's-
address
it's a-
that, Judge.
You're gonna address it? All right, I'll
Yeah.
give Attorney. Still gonna hear from Attorney Ho, Attorney Starmay. So
That's fine. You can hear from Attorney Ho if you
Yeah.
want. I understand.
Yeah,
Judge, if it's gonna help the
go
court.
ahead. Go ahead, Attorney Ho.
The license, like other licenses, are regulated by the Department of Consumer Protection. There's a license for a martial arts club, and then in addition, there's martial arts clubs are, like other health clubs, are subject to the inspection to have emergency AED. If someone had a heart attack or something, equipment, and their contracts are subject to the Department of Consumer Protection cancellation policies that are required of consumer contracts.
So sounds like any other gym.
It is a gym, but it's a
It's a
kind
gym.
of gym. Yes.
It's a kind of a gym. Okay. All right. Thank you, Attorney Ho. Attorney Starmay, go ahead.
Yeah, let me follow up with that first. They are also subject to the Office of Early Childhood's regulations, depending on how much the children are supervised or not supervised, if the parents are there, how old are the kids. These are all, how long are they there? These are all issues that very well fall within the penumbra of Office of Early Childhood. Office of Early Childhood has an interest in this. Now, whether they can structure things so they actually get out of the regulations, sure, they sometimes can't. They often can't. But they are careful about that. There's regulations and limits in terms of how long these classes can be vis-a-vis the Office of Early Childhood, depending on the age of the children who are being taught too. So these are parts of. Just because it's not actually regulated doesn't mean it's not part of an issue of public concern. I'm not sure grocery stores were particularly regulated around issues of COVID, but nonetheless, they were an essential part of the public function. And there was a great public interest in grocery stores, right? And we don't normally think of that, but absolutely there is. Is it serving the public in some meaningful way? My adversary is trying to bring this to some narrow construction that doesn't actually exist in the case law. And I just want to flag that for the court, that could be that's an attempt to induce error. It's furthermore, Judge, it's not on us to show, we only have to show whether it's in connection, which is a very loose, in connection with an issue of public concern. We don't have to be the ACLU, Judge. We don't have to bring a public interest lawsuit. That's not the issue. If something affects the public in some way, whether holding a business accountable, that's the issue.
But I mean, and I guess that's back to my earlier question. That's everything, right?
Judge, and it has to be
Essentially, it's everything. Everything is right. If you keep stripping it away, everything at some level.
Judge, I'm not going to put the limit out there, because I think that as Judge Elgo points out, that could be a very deep hole. It looks like it's a very deep hole. I'm saying under these facts, where we have a business that's serving children, specifically targeting the morals of children, we're talking about something, their physical safety. I also have a lot of history around martial arts schools, Judges, so that indicates that they have always been an issue of public concern. The teaching people how to fight has, for hundreds of years, going back to well before the Republic, has been an issue of public concern. But
voluntarily, right? Though the people that are there are choosing to be there, and they can leave at any time.
Yeah,
right?
so could the general militia would do the same thing, right? They would go and they would, but I don't understand. I guess the court has a point, but I'm missing why. So if I feel like I'm not answering a question of the court has this issue around people's voluntarily ability to leave, and I'm not sure how that's relevant.
I guess I guess really what I'm trying to get at is you're saying it's a matter of public concern because they're teaching morality to children, right?
Yeah.
Okay. And I'm saying, but that's voluntary on part of the people who are choosing to attend, right?
Is it only I don't think it's only a public interest if it's mandatory. People can go to Sunday school would be an issue of public concern, right? Whether something is, and that's definitely not mandatory attendance, right? So the ability for people to go and worship is an issue of public concern. Historically, our republic is based on it. This republic, Connecticut, is based on that. So I don't think mandatory attendance makes it in connection with an issue of public concern or not. We're not going to a grocery store isn't mandatory either.
Okay.
But it's still an issue it's in connection with an issue of public concern. And what it means to be in connection with an issue of public concern, we briefed this thoroughly. It's not a particularly onerous showing. It's a very permissive showing. I'm sorry, Judge, I interrupted His Honor.
No, but I mean, it sounds like what you're saying is this dispute, right, in the counterclaim, right?
Yep.
And that gives rise to a matter of public concern. Yes?
It's in connection with, doesn't have to give rise to one, Judge.
Okay.
It has to be in connection with one, which is which is different.
The dispute
Some relationship
in the counterclaim is related to a matter of public concern.
Yeah, the proper yes, opening the books to see whether this is being operated fairly, ethically, correctly, legally. That is an issue of public concern. Parents are investing in this business by being patrons of it. Children are attending it. It goes to whether this place is, as the court points out, this place may not be open because of what we believe to be improper practices. That may deprive people of
But is that a public concern, or does it really only relate to the people who are part of that martial arts studio?
Well, the public who do they serve, Judge?
Whoever decides to go and whoever goes and goes and chooses to attend.
And their children, and those are people in the public. Yeah.
Sure.
So I'm saying they're serving the public. They're serving important members of the public. They're serving important members of the public in a particular way.
Well, they're serving their patrons.
Yeah, their patron. Yes. I don't think that makes it not an issue of public concern just because it can be framed as a business. I don't think that makes it not an issue. I think lots of businesses are, childcare, private childcare. That's a private business, Judge, right? They're regulated heavily, but it's a private business. It's still an issue of public concern. Right. So I don't know that just because it's a private business doesn't take it out of the issue of public concern. That seems to be exactly opposite of the construction that the appellate courts have given. But, if the court finds the argument persuasive, it's very forgiving. Community well-being. Does this have to do with community well-being? The availability of this martial arts studio, whether this martial arts studio is being run ethically or not. Absolutely, I think it does, because they're teaching morals to children. So it's also not on me. My adversary tried to flip the burden. It's not on us to show likelihood of success, or that it's on them to show with particularity, which they only did once so far, that they can overcome all of the applicable defenses. And they've only identified one statement with particularity. They've thrown hundreds of pages at the wall, hoping something will stick. And even with the one they just brought up, the phrase was, and I'm going to use the exact words, I'll kick your hick ass. Right? Okay. And they're saying that it was a lie to call that a threat. It's a lie to call that a threat. They have probable cause to show that is a lie. Okay. This is the first time they've raised that. They've tried to address that. This is the first time. Their argument here, only the things that they talked about here. It's their job to show that for any of the statements at issue, for each of the counts that they're relying on, that they have probable cause to overcome. And they haven't done that. They have abandoned the field on this. They haven't done it with particularity, Judge. They've thrown hundreds of pages at the court hoping something will stick, but that's not what the statute requires. The statute requires particularity. I pointed out how they have to put on evidence with particularity. I pointed out we don't have to be the ACLU. We don't have to plead a public interest in our. We don't have to plead a public interest. It just has to be in connection with an issue of public concern. Another case I had involved damages to someone's lawn in public. We don't have to communicate in public on this one either. It's not. We don't need to be talking on Facebook when petition is at issue. When petition is at issue, it can be a private communication, Judge. And these are private communications about this lawsuit, about in anticipation of this lawsuit, in connection with this lawsuit. And this lawsuit is in connection with an issue of public concern. These martial arts schools that serve the community, that serve children. It's not just, something that deals with the market, that deals with private people's managing wealthy people's money in some way. That is completely has no connection to public services. This is a public service. It's not a government provided public service, but it's a public service.
Do they charge for it?
They can, and of course they do. Just as we charge taxes for our public services that we give as
Well, that's government. I'm just saying here they're not just voluntarily giving out free lessons.
They don't have to be, Judge, for it to be an issue of public concern. I don't think that it's limited to volunteer work. I don't think that.
You said it's a public service, right? So
it is.
That's what that. Well, how so?
You can charge money and still provide the public with a service.
I mean, but it's not. This is not like this is not a nonprofit entity, right? This is not like.
Does it have? I don't think it has to be, Judge. I don't.
No. I'm asking the question. I'm saying this is a private enterprise that you're saying serves the public, sure, but like any private enterprise, it's subject to the laws of capitalism, right? It can do well, it can not do well, it can open, it can close.
Sure.
Right. And
it's also
the patrons have no say in any of that. Right. They're just there to learn if they're able to. If they close tomorrow, right? If they close tomorrow.
They have an interest in whether this one that they like is open or not. It's not about whether they have a right to it, Judge. It's about whether they have an interest in it.
Well, they have sure they have I guess if they have an interest in it, but they have no say in any of it.
That's not the issue. It's about whether there's a public interest, not whether they have control. That's reading the statute too narrowly as to what is in the community well-being.
So what's the interest?
We outline this more thoroughly in my brief.
Okay.
But a very important one is the education of children. A private school, Judge. I can't imagine that we would argue that a private school that taught children or home, even if it's a religious school,
right,
but that's not something that serves the public interest. The availability of private education is certainly in the public interest. This is an analog that doesn't teach reading, writing, arithmetic, but as the defendant says, teaches children virtues and how to protect themselves. It's about their physical well-being. Parents have an interest in their children's physical well-being and their children learning to defend themselves, particularly young girls, let me say. Learning how to be aware physically of your surroundings, strategies in order to protect yourself. This is something that gives children something valuable, as well as, of course, the moral education, because we don't have that necessarily in public schools in the same way. So parents can direct their children's moral education by choosing to have them attend these schools. That's really important. That's something that the public has an interest in. And it's an issue of public concern when there's bad faith, bad dealings vis-a-vis the money that these parents are spending on these schools, when people are going to make them unavailable because they have secreted away money, because they're not being transparent with or fair the head teachers are not themselves acting in an ethical way.
Well, it sounds like
And
though,
that's
then
something
you're
that the
saying
parents have an interest in.
it sounds like you're saying the public interest in this context then it goes to the management of the business.
There's
That's where
two parts to it, Judge. There's two parts to it. You're right. In part, it's about the management and whether the business is available. But this management, it's not just about money. This management is particularly attached to the moral education of children. They say so themselves in their affidavit. That is different. That makes this different from most corporations, from grocery stores. They're not about the moral education of children. And so that's what this lawsuit is about, whether holding someone accountable who teaches children, teaches them morals and ethics, and is the head teacher of a program for that. Of a private school, sure, but one that parents do have their children attend. This is where we're getting to community well-being.
Was that what your complaint's based upon? The fact that there's a lack of moral teaching going on at the school that needs to be remedied? Is that the
We don't have to
basis
put
of
that
it?
in the text of the complaint for that to be
What is your complaint about?
about
What are the-
hiding money.
It's about hiding money.
Yeah, we want
It's
to
about
actually
money.
just see the money. We want to see
So
the
it-
money, but they're not showing it to us.
All right, so
we
it's
must
about money.
assume the worst.
It's not about moral education, it's about money.
In a business that is about the moral education of children.
No, I get it. But you're not
Secreting
suing.
money in a
What are you
business
suing for? What are you suing? Say you won
to
your
open the
lawsuit.
books, to hold the leadership accountable.
Because your client feels he's owed money that wasn't appropriated. to him,
Because they have
correct?
secreted away and they're hiding things, Judge. We're just
Okay.
trying to open it to the light of day. We started this just to open the books, not
All right,
to
you
try to make all these other allegations. This began, and the alpha and the omega of it is, let us see the books. Let's show people how this money is spent. That's what this is about. Uncovering things, about getting
Uncovering
knowledge
money.
about things. Of
Right.
course, there's going to be a financial component, Judge,
Huh?
because I have to get paid at the end of the day.
All right, your
There
time
must
is
be.
up.
But we
Last
don't
word.
have to be the ACLU, as I said, Judge.
I know. All right. Anything else? Your
If there's
time's
no
up.
further questions, Judge,
Okay.
if there's
All
no
right.
further questions, I'm just, then I'm
Yeah.
done. If there's no further
Okay.
questions.
All right. Attorney Ho, your hand has been up. Everything okay?
Judge, I object to Attorney
Yeah,
Ho's
no, I
participation.
just,
Well, I didn't know what
I-
her
I'm
hand
just-
was raised.
I'd like to sort of give the judge some information with regard to the regulations that cover the company, since I'm the company lawyer, just to, just so that the judge,
I'm
the
going to say
company
one
is
last
not,
time I object to her participation in these proceedings.
I-
That's all,
listen, I
and
think
I'm
she-
rest.
Yeah,
That's all I
that's
say,
fine.
Judge.
Yeah, I mean, I'm satisfied with your previous commentary. I was just kind of generally asking about regulations regarding to martial arts studio training. So I don't need, in terms of resolving this dispute, I don't think it's, if you want to
Those-
tell me.
yeah, what I told you were the only regulations
Yeah,
that govern.
that's fine.
And it covers, it's a health club.
Yeah.
And it's not regulated by the State Department of Education or the Office of Early Childhood. It is not a child care facility, and it's not a Head Start program.
Okay.
So that's, I just, in terms of having the facts be clear, that's all. I'm not taking a position with regard to the arguments.
All right. Thank you, Attorney Ho. All right, Attorney Wilson, go ahead.
Yeah, I mean, I think that the court hit the nail on the head. This is and always has been, from prior to the litigation, as we've demonstrated through emails, all the way through the current time, is solely about the money. This is Andrew seeking an award. If you look at the relief requested in the complaint, if you look at the allegations in the complaint, it's all about personal business funds that he claims that he's entitled to, which by definition is not of public concern and by definition is frivolous. And the suggestion that this complaint somehow implicates Office of Early Childhood Development or any other regulatory body is simply a falsity. Where in the allegations of the complaint, let alone the counterclaim, are the references to early childhood education, the virtue of children, anything like that? It's completely devoid of anything like that. Completely devoid. And with respect, I mean, I think that the level of generality that you're seeing here is exactly the level of generality that the court in Chapnick and Delora was very, very clear did not apply and was not available to applicants for relief in a special motion to dismiss. You cannot extrapolate from the specifics of a business dispute out to general public interests and use that to establish public concern. And specifically with respect to interests, right? The interest that the court in Sicca-Giannano was talking about in connection with is the recipient of the statement having an interest in in that petitioning activity, the petitioning of the government activity. Not a single person shown in any of these statements has any role in this litigation or any plausible connection with this litigation at all. And interest, as the court in Weinberg stated, which was adopted by Robinson versus VD here in Connecticut, interest does not equate with curiosity. They're not the same. And so I think that it's crystal clear, both in the Chapnick case as well as in the Connecticut cases, again, that hold that business disputes, again, applying the same exact standard for frivolousness here in Connecticut as they do in California, find them to be frivolous when they're brought in the business context. And I'm reading now from the Workman versus Collickman decision, and it talks about this prohibition on extrapolation, and we've covered it very clearly in our brief, this prohibition on extrapolation from private business interests to general public interests. And again, there's language on it from Chapnick that I'll try to get to if I can. But this is the language from Workman. Defendants assert that the public interest at issue here is the fraudulent practices of a real estate broker in marketing real property to the public. This contention vastly overstates the issue in this case, just as being done here. Collickman's communications to donor was about defendants' construction plans on their own home and the potential effects on the views from the neighboring trust property. Defendant's argument that this case does not involve a specific private transaction and instead involves fraud in the marketing of real estate in general is not supported by the record or applicable authority. Just like this context of some sort of early childhood development being drawn into a complaint that makes no mention of it anywhere. This is back to the opinion. The fact that a, quote, broad amorphous public interest, like the one that my brother has been referring to constantly throughout this hearing, can be connected to a specific dispute is not sufficient to meet the statutory requirements of the anti-SLAPP statute. By focusing on society's general interest in the subject matter of the dispute, instead of the specific speech or conduct upon which the complaint is based, in other words, the speech to business members of the business who don't have an interest in the litigation about the business, other than maybe a curiosity associated with this litigation, but not an actual role or stake in it.
And it would have to be the speech in your counterclaim, correct, Attorney Wilson? That'd be the target.
Well, the speech and the counterclaim, but at the end of the day, it really is the complaint. The complaint is the theoretically possibly, the only theoretically possibly protected activity, and that's the speech that has to have in other words, that's the petitioning activity that has to be on something of public concern. And then the statements
but the context
about
here
the litigation.
The context here is a motion to dismiss your counterclaims, correct?
Correct.
Okay.
But
so that in terms of the matter that reached to public concern, right? Would they be limited to the speech contained within your counterclaim? Or would it be the complaint, or would it be both?
It's the counterclaim, but it extends back to the complaint, right? Because the statute requires that the underlying petitioning activity that they're seeking to protect,
right, is
on a matter of public concern, right?
Okay.
And then the speech so it's a blend of the two, but if the complaint isn't on public concern, isn't demonstrated to be on a matter of public concern, which we've clearly shown it's not here, then the fact that he may be talking with somebody else about that complaint doesn't convert that to public concern. There's no case that holds that. There's absolutely no case that holds that. And these cases that I'm citing to finding frivolousness in California, and by the way, authority that hasn't been referenced at all by my brother, despite the fact that he's touted the fact that California is where the Connecticut cases look to for guidance, and specifically where the abuse of the anti-SLAPP statute should be looked to, because they've been dealing with it for over 20 years, as referenced in the Weinberg case and extrapolated through the progeny that we've cited in our brief. But let me finish the quote. Defendants resort to the oft-rejected so-called Sinodoki theory of public issue in the anti-SLAPP statute, where the part is considered synonymous with the greater whole, right? That's what's prohibited. That's exactly what he's been doing here. And then for the context of the statement, him suggesting that there was actually some sort of physical threat, you need to read the whole text string. And this is from 79 of page 79 of the docket 138 that he's referring to. And I'm just going to start midway through. Tomorrow, this is my client talking to Andrew. Tomorrow is a snow day. Stop making excuses to stay, and in other words, stay at the studio. And this is at 9:35 p.m. and go the fuck home to your fiance. Are you in the car yet? No, almost. Why? Go the fuck home. What is your excuse for not being in your car yet? I have to go to the bathroom. Go to the bathroom at home. Right? And then I'm headed down there, and if you're still there, I will certainly kick your stupid Stafford hick ass. No need, I am in the car. Then I'm going to your house, and your rice-burning car better be in the driveway. It will. Text me when you get there. Are you home yet? This is at 10:01. Again, the night of a storm, right? Then a question mark at 10:03. 10:15, yes. In other words, yes, he's home. So suggesting that there's actually a physical threat here is a lie. That is just simply not accurate. The full context establishes unequivocally that that is a lie. And so to hold up a phone from the video that I was going to show, and I can, it's in the video, and I've given you the references, and you have the video, so please take a look. To hold up a phone and say, I have a text where he physically threatened to beat me up, without providing the context of the rest of the discussion to students, to business associates, is objectively false. That is defamation. So for him to suggest that he somehow physically threatened him in a text is just simply false. It's not accurate. And we've provided exhaustive examples of statements that very clearly establish, and evidence as well, breach of fiduciary duty, of breach of confidential and protected information. All of these things are much, much broader than just this defamation claim. And again, the courts in California are very clear that just the timing of a filing is not a factor to be considered. And by the way, counterclaims are required to be filed within a certain period of time if they are to be filed at all. So there is no connection. There is no retaliation associated with this. These were longstanding issues, and if you look at the numbers that we've provided in terms of the decrease in the student numbers, you will also, and the profit numbers while Andrew was running this, show exactly why Mr. Shirley has counterclaims for breach of fiduciary duty and otherwise, and we've provided very clear proof of that, Your Honor.
Okay, thank you.
Judge,
hold on. Thank you, Attorney Wilson. Attorney Sarver, go ahead.
I have the burden.
Yeah. So yeah, I was gonna say, do you want a couple of minutes just to respond, because you are the movement.
Thanks, Judge.
I'll give you 5 minutes. Go ahead.
Thanks, Judge. My adversary is trying to turn step one into a merits inquiry, which this is not. That's not what this is about. This is not a merits inquiry. This is about in connection with a matter of public concern. We talk about this in Siciliano versus there's a 2025 case. Siciliano, which my adversary points to repeatedly. It's very good opinion. It's an opinion on point vis-a-vis the right to petition, which is distinct from the right to free speech. Because the right to free speech has to have this public forum element. We don't have to have that when it comes to the right to petition. In connection with any factual, contextual, or causal relationship to the litigation. It's really broad. I would encourage the court to take a close look at Siciliano, the AC's language. So it's not we don't have to be talking about the things that my adversary says that are not in the complaint. That's not the issue. Any connection. So, and that's the two biggest ones. My adversary is trying to turn this into a merits-based inquiry at step one, which is a mistake. That was the mistake in Brignol. And in connection with the way that our appellate courts have construed it is very broad. That's all I have to say, Judge.
Okay. All right. Well, listen, I appreciate all of your arguments. I know council's put a lot of time and energy and effort into all of their pleadings and supporting documentation. I will review all of that. If necessary, if I need more explanation or argument, I'll let you know. But for now, I'm going to take the matter up and we'll go from there. Okay?
Very well, Your Honor.
All right. Thank you to you all. Have a good rest of the year if I don't see you. Take care.
Thank you.
Court
Take care.
stands in recess. Thank you.